Hi, everyone. I'm attorney Donna DiMaggio-Berger, and this is Take It to the Board, where we speak condo and HOA. Has your association ever been confronted with someone creating a shadow website or social media page that looks like it is your official association website or media page, but it's not? Have you ever had a local business trade on your community's good reputation by incorporating your community's name into the name of their business? These kinds of problems are not as rare as you might think, and the solution to preventing and resolving them is usually just one registered trademark away. My guest today is my partner here at Becker, Valeria Angelucci, who was born and raised in Chieti, Abruzzo, which is in Italy, for those of you who are not familiar. She earned her law degree from Roma Tre University in Italy, and then went on to obtain another law degree from Nova Southeastern University. Valeria is an attorney in Becker's corporate practice, where she uses her international background, experience, and language skills. She speaks Italian, Spanish, and French, in addition to English, naturally, to assist her clients in the areas of corporate finance, mergers, acquisitions, and divestitures, securities, SPACs, and general corporate governance matters. Today, we're going to be focusing on her work with community associations to protect their intellectual property, namely their names and logos. So, Valeria, welcome to Take It to the Board.
Oh, thank you, Donna. I mean, that was a great introduction. Now I feel very humbled, and I don't know if I'm going to be up to the task, but I'm going to try. Thank you for having me here. It's the first time for me on a podcast, so that's going to be interesting, but hopefully I can kind of like help you, give you some information, useful information to people out there.
I have no doubt you will. And after looking at all the languages you speak, I like to say I speak Spanish and some French, really just menu Italian. I would never take you on linguistically speaking. So the first question I wanted to ask you, just to set the table for our listeners, is, can you explain the difference between trademarks, copyrights, and patents? Because I don't think any of our clients need patents, and why trademarks are particularly important for community associations.
Sure. So basically, these are all examples of intellectual property. Intellectual property is something intangible. It's not something you can hold in your hands or like move around. And these are all types of intellectual properties that can be actually registered with the USPTO. So, for example, let's say you're thinking of a new way of producing something. So there is a new process for producing a product, or a new way that you're gonna, create like a medical device or some medicine or anything like that. So when it comes to an invention, so it's gonna be something that is new, that it's not actually already in commerce, has not been produced by anybody else. It's something that is useful, and it's something that is not obvious to people. That's going to be a patent. So when you register the patent, what you're doing is actually saying, I have a right to this process, this invention that I just developed. And from that time on, nobody else can use that. So an example of a patent could be, for example, again, like, medicines. Those are like old patented things. Or even, for example, how certain electronic devices function. These are all patents. And no, probably I wouldn't think that associations are ever going to need to register a patent. I mean, anything can happen in life, but that's not probably what you're going to come in contact with.
Do you know when the first patent was registered in the United States?
I'm not sure about that. No, I think it's probably going to be like the 1800s or something like that.
And I may explain acronyms. So you said USPTO. I know what it means. Do you want to tell our listeners what USPTO means?
So US stands for United States, and PTO stands for Patent and Trademarks Office. So that's basically the agency that takes care of anything related to patents and trademarks in the US. If you're registering in a different country, then you're going to go to that country patent office or trademark office. Usually they're in the same place, but that changes. And then I can move to copyrights if you're okay with that. I don't know, unless you have any other questions on patents. Okay.
Andiamo.
Okay. So copyrights. When you're thinking of copyrights, you need to think of something creative. So it's going to be a song, or maybe you wrote something. It's a poem. It's a novel. It's like a short story. And it can even be like a drawing. So those are all copyrightable work. And what happens with copyrights is that it's your rights to the authorship that is actually protected. The thing with copyrights is that they actually they actually happen the moment you create the work. You're not required to register a copyright. It's a common law copyright, right? And if you register, though, you're going to have enhanced protection, because from that point on, you're making it public for other people to know that, listen, this is my work of art, and you're not supposed to reproduce that, to copy that, to alter that, to create derivative products or anything like that. So whenever you have a song, whenever you have something creative, that's probably going to be a copyright.
Probably not applicable to community associations, to a condo.
You never know. Maybe you come up with like a song for the association or something like that. I don't think that's,
you know what, that might help them. A nice peaceful song at the board meetings, that might be something that they should consider. But okay.
Yeah, something like that. So, the difference between patents and copyrights is like, patent is like useful stuff, like a new invention, something useful. Copyrights are creative things. And then we're going to move to trademarks, which is a different sort of thing. So a trademark is basically a word, a design, or something that is used in connection with a certain good or a certain service. So let's think of like something that you associate with a certain brand, for example. And it can be even colors, it can be even sounds. And that's where you can have like a little bit of like a in-between between copyrights and trademarks, right? So everybody knows, for example, Apple, right? When you see the Apple logo, when you see the logo, you know that that's Apple that is producing that device. So I make that connection instantaneously between the product and the company that actually created that. And the same thing works for, with example, for let's say the red Louboutin, the shoes that they have like the red sole, that's actually something that was like trademark.
Louboutin? Yeah, don't ask my husband to look in my shoe closet.
Yeah, another one you're gonna like, the Tiffany blue.
The Tiffany blue box, absolutely.
So that color is actually trademark, because
wait, they could trademark that particular blue as Tiffany blue.
Yes.
But can I use it on something different? Can I use Tiffany blue on a vehicle?
So yes, you could. And that's where, that kind of like the thing with trademarks is it's really associated with the type of good or service you're providing. So let's say, we have Apple, and of course, Apple makes, electronic devices, I guess, phones, iPads, whatever. So if you see that logo on, let's say, like at the grocery store, you're not thinking, oh, wait, this is Apple, the company Apple that actually created this, like, I don't know, box of cookies or whatever, That's where it's really important to make sure that when you have a trademark, you're clearly defining what it's going to be the product you're going to be selling or that's going to be used in connection with the mark, or what is the service. Because the thing with trademarks is actually, we refer to trademarks generally when we refer to both actual trademarks, which are the ones that are used with products, and service marks, which are the ones that are used with services. We just use the term trademarks because, it's just easier. But in theory, they're two different things.
Is it fair to say that these protections are all designed to avoid confusion in the marketplace?
Yes, that's exactly the point. So the idea behind that is, again, if I'm going to Apple and I'm buying something that has, I'm just using Apple because it's an easy thing for everybody to think of, right? So if I'm buying a phone and I see the Apple logo on the phone, I'm going to say, oh, this is an iPhone. And I rely on that specific phone because I'm thinking, well, this is Apple. I know it's a very good brand. I know it makes very good phones, or it has very good technology. So I'm going to buy that thing because I know it's connected with that company. And the same thing works with pretty much everything else. So, if you're buying a pair of Louboutin shoes and you're buying them and they have the red sole, and then you actually find another pair of shoes that have the same color, but they're not Louboutin, you could be confused and you could be like, hey, I thought I was buying Louboutin and I know I wanted to buy Louboutin because that's really great. And instead I bought this like Chinese made copy.
But Valeria, if you're spending $75 thinking you're getting real Louboutin shoes,
well,
you should probably know better. But you just raised a question for me because we talked about confusion in the marketplace. One of my associations, what tends to happen, and I mentioned it in the introduction, was that they had a real estate company, that this is a very large community with thousands of homes. And this realtor put in the name of their company, they started out with the company name, broker, real estate broker, LLC. So they wanted people to think that they were the official broker for that community. So what can that community do? I'm assuming, if I'm listening to, that a trademark is what could help that community in shutting down another business from trading on their good name.
Yes. So I think it's always better to register the trademark. I will just mention like very briefly that in theory, you are covered, you have some rights, even under common law trademarks. So you don't need to register something, but the problem is gonna probably come is that it's gonna be more complicated for you to prove that, hey, this is the mark I was using even before you started using that. And this is associated with my association or with my company, or whatever it is. So that's where registering the mark makes it like more protective for you. But yeah, the problem in a situation like that is exactly that. You may have somebody else who's using a similar name or a similar logo, and then it doesn't have to be intentional. Of course, if it's intentional, that becomes, even worse. But you may be just somebody that in good faith is using something and it's like very similar to what you're using. And maybe, it's like in your case, a real estate company that is advertising units, maybe in the same association, or maybe, is doing business very close to the place where the association is. So it would be normal for people to think, oh, look, this is the same name. It's kind of like the same logo. So this must be the same, this must be kind of like under the same umbrella. This must be the person that is probably allowed to sell for the association. Maybe I need to go to this person if I want to buy a unit in the association. That's
Correct.
not true, of course, right? But that's really what the issue becomes. And that's when, having a trademark registered actually helps you, because it creates a presumption that, no, this is my mark. It's valid. I've been using this since whatever date you've been using that. And that's all going to be in the application you prepare and file. And it's going to give you a little bit more protection.
So let's talk about the statute of limitations. So we've got this realtor who's using our name to try to sell property, to try to give the impression that that real estate brokerage is affiliated with our community, which is a large community. What's the statute of limitations to enforce? Let's just say we only have a common law trademark. We haven't registered the mark.
I don't think the problem is really with the statute of limitation. I will mention that the issue is more what happens if you don't do anything. It doesn't matter, like, even if you do like a little bit, like, it doesn't have to be the same month you figure out this is happening. But the problem is that if you don't do anything, regardless of the statute of limitation, what happens is you're not doing anything to protect your mark. Nothing happens for like 2, 3, 4, 5 years. And then you're back there and you're like trying to argue that you own the mark. And at the point, the mark can be considered diluted and can be considered like, you kind of like lost your rights in a way. The thing with trademarks is you have a right to use that mark and to use it in business for your products and to be protected in case, and to enforce your rights in case somebody else is actually using it and they should not be using it, right? But if you don't do anything, then it's kind of like you're abandoning your rights. That's the issue there. It's really not regarding like statute of limitations. It's more like you have a right. And remember, if you have a right, you still need to make sure you use your right. If you don't use your right, you're just giving it up.
That was always my understanding as well, which is once you actually, if you actually register it, that you have to protect it or you lose it. But I assume, and I want to get into, federal versus state registration. But I want to give you an example. Let's say an association comes to you, and we've had this because you work with me, you work with all of our associations, and they say, we have somebody setting up a shadow website. They've got a picture of our monument wall with our name on that page on their website, also on their Facebook page. They've got our name. What can we do? At that point, what kind of trademark protection? Let's say they want it. They're saying, tell us, should we register federally? Do we need a Florida registration or state? Because we got people listening in other states. And if you could speak to the costs involved.
Okay, so I first want to just highlight one thing. Just because you're using a name, it doesn't mean you're going to have a trademark, okay? And I just want to make it very clear, because sometimes it's easy to think, well, I'm using this name. So, I working for Lauderdale and I'm using like for Lauderdale real estate company, whatever. So now I'm going to trademark for Lauderdale as a trademark or whatever. That doesn't work, okay? Like a trademark needs to be something that is a little bit like distinctive, doesn't, it cannot be like a very simple term on its own that is used in association, for example, with the geographic area, let's say, okay? So that's a first thing I want to just highlight. As to cost, it really depends. So if you are in Florida, most states, I would say, have some trademark laws, some trademark statutes. So you're probably going to be able, even if you're not in Florida, Florida has a specific statute. Other states have statutes, some may not. I mean, on top of my head, I don't remember all of them, but I would say most have some sort of protection and some sort of registration. The Florida, I will talk about Florida just because that's where we practice mostly, but other states have something similar and the costs are usually similar. For Florida, the process is way easier than the federal process, right? So what you need to do is literally provide a few examples of how you use the trademark. You're going to have to provide information for who the owner is. So in this case, it's going to be an association. And you're going to certify that you're using the trademark for a certain service. So usually for an association, probably what you're going to be doing is market the association out to potential buyers or potential new residents, or you're going to protect the association. You're going to enforce the rules and regulation of the association. This is probably what you're going to be putting as the services in there. So some sort of like real estate association related services. The cost is really, for Florida, is like very low because it's basically $87.5 for one class. You probably just need one class for an association if you're just doing the sort of things I said before.
Right, you're not selling merchandise. Some of our timeshare resorts actually do license, apparel and cups and beverage containers and things like that.
Yeah,
you need another class, right, for that?
Yeah, my point exactly that. So I'm talking like most associations, they just do like, their association work and they have nothing else really that they're going to use the mark for. But if, for example, you have a restaurant that you have on your premises, or if you're, for example, you have some sort of other activity, so you're like selling shirts with, your logo on and things like that, those are all different classes. And that's where it comes, where the issue comes, that you need to kind of like check, okay, what type of work am I doing? Am I doing cups, or am I doing shirts? Am I doing travel arrangements? Am I like renting kayaks? You can do like many things, right? So you need to check what is the service, what is the good, and based on that, you may need to register for 1, 2, 3 more classes. So $87.50 is really for one class. That's probably most likely applicable to the majority of the association, but doesn't mean that you need to just stick to that. You can do more things. One thing that is very important to note is that Florida is only allows registration of marks that are already in use. So that means you need to have been using the mark on the caps, the shirts, or for like your letterheads, or like your newsletters, whatever it is, but you need to already have been using that for a little bit before you can actually register in Florida.
Would a website count, Valeria? So in other words, they've got the name and the logo on a website?
Yes. So for Florida, you're going to need 3 specimens. So usually that means 3 different examples. Where website works, okay, that's not an issue. But usually, let's put it this way. If you're using a name, a logo, or something, you want to try to be consistent. That's going to be part of kind of like your goodwill, kind of like your your image outside for other people. So you try to use that as much as you can on whatever is related to the association. And that way it's going to make it easier also for other people to kind of realize, hey, I got this letter. This letter comes from the association. It's not coming from, my neighbor who's acting to be the association. Or if that's the case, then you shouldn't be doing that. But that's a different story, right? But yeah, so the websites are definitely very useful, and we use websites a lot when we need specimens. It's just, I want to make sure you understand it's not just websites. Some people think, I use my trademark on just like one thing, and now that's it.
Gotcha.
It needs to be distinctive enough. Like people need to understand that's you acting, is the association acting using that logo.
So let me give you an example and ask you if these would be examples of potential specimens you could submit for the registration. In my HOA, it's a golf course community. So when you come to the entrance, beautiful signage with the crossed golf clubs right there on the monument wall. When you go throughout the neighborhood, you have that same signage with the crossed golf course clubs. Could you use that as a specimen?
Yes, absolutely.
Street signs, monument walls, other kinds of signage
That's
throughout the
perfect.
community?
Yes, that's perfect. I like just to make the application a little bit more persuasive, to maybe show different things if possible. So, even just the letterhead or the, business cards for somebody or the website. If you use like more, different things with the same logo, I think it's going to make your application a little bit more persuasive. It's probably going to be easier to move through the process. And for I'll just note that for an association, it's probably easier to use like signs and things like that, because of course, you're just referring, hey, this is like kind of like real estate services related to the enforcement and marketing of the association. But now if you're using the same marks and you're using them for like cups and shirts or whatever, I'm going to need to see those marks applied on that type of product. That's not going to work for that class at least.
So you mentioned that not everybody's eligible to trademark a name, and I get that. Like I gave you the example of my association, Valeria, which does have a very distinctive logo, right? It's actually a shield with the crossed golf clubs. Does every association need that kind of logo, or I don't even know if I'm saying the right terminology. Is that considered a logo when you have a graphic, or is that something else?
No, you can call it logo. It's a design. So usually so a trademark can be the wording, could be the design, or could be a mix of both. So, if you're thinking of, let's say Nike, right? The brand Nike, you're going to see the little like check, and that's a design, right? It's just like a drawing, and you can see that on its own being used. And then sometimes you see that used with the Nike wording, which is in certain specific fonts, right? So you can have a trademark
You're
that
referencing
uses
Nike, right?
Nike. Yes, Nike. Sorry, like the Greek pronunciation would be Nike. But yeah, sorry. Yeah, Nike. So in that case, for example, Nike probably has a trademark that is both to the design, to the wording, and probably to both of them used together. And that's how it kind of like protects attacks from every side, let's say.
So it's stronger with the design, and that would hold true for associations as well, right?
Yes. So the point is, if you're just using wording, then it needs to be something like very particular. Okay. Again, you cannot just say, for Lauderdale and use that as this is going to be the mark. It needs to be something, different, something creative, something that is not telling you this is related to this association just because of the name. Okay. So you can have a name that is just like, made up, like, I don't know, Lululemon. That's not a word, right? So that's enough, like you're saying, okay, I'm using this word and that's the mark. You can have like designs. I would say probably if you have like a wording and a design or a mix of the two, is probably easier for you to get protection, just because, again, you're thinking of somebody else that is looking at the product or is looking at the service and looking at this thing and is like, okay, what is that? If it's very particular, it's going to be easier for you to remember that as a thing and related to that certain, company, association, or whatever it is.
So we've got, listen, our associations run the gamut from very small to very upscale. Okay. Maybe the very upscale communities have brand consultants, but I'm guessing 99% of the community associations don't. But let's take a community that has a name like Island Club. Okay. And that's all they were, when the developer turned over, that's all they had was this name Island Club. Would it be possible for that association then to decide we want to add a palm tree? Maybe we want to add 2 palm trees around our name and trademark that. Can you do it? I'm assuming you can do it after the fact, but you would have to look and see if there's any other island clubs out there that have that design. Is that how that would work?
So, okay, so it depends. Meaning, and of course, we're talking generally, we're not giving like specific advice here.
I should have said that thank you, my colleague, for saying that. We are not giving specific legal advice. This is a podcast. This is for general education and entertainment purposes only.
So, okay, let's put it this way. Let's look at that, under, Florida and under federal, because it's a little bit different. Okay. For both of them, you're probably going to need to check if somebody's using something similar. So what I will do, generally speaking, when I get somebody that wants to trademark something, is I will try to look for something that is similar. And when you have a design associated with the wording, for example, that design needs to be described in the application. So there are ways to kind of look for that. It's never perfect. Sometimes something may come up and it didn't show when you were first searching for that, but that's how you will do it. Now, if you're doing, so like in your case, you're saying, okay, well, we were using Island Club, is the name. Okay, so you're just using Island Club, and now you're like, well, we kind of want to use it as a trademark, but we need to add something, right, to make it more of a mark.
A little pizzazz to it.
Yeah. So you're like, we're gonna just add these palms and stuff like, okay, great. Now, if you're in Florida, again, you're not gonna be able to register that because you haven't used that. So that's the first thing you need to keep in mind, right? If you are starting to use that and you've used that like for a little bit, now you can go to Florida and say, okay, now we're gonna register. But if you're doing that before you actually start using the mark in commerce, which will mean, again, publicly, you cannot do that. For federal, you can do that. So for federal trademark applications, you can actually have two different types of application. They're kind of similar in the way they work, but one is based on using commerce. So you're saying, hey, I've been using this mark for a while, and this is how long I've been using that for. And the other one is, hey, I have this mark and I have all the intention to use that in commerce. And you can register that before you even start. Well, you can register. You can apply for registration before you even start using that. You will need at one point to show you're actually using that after a certain amount of time, because otherwise you're gonna kind of like give up that sort of like reservation on the mark. But you can do both. So that's the first thing you need to keep in mind. So in Florida, you need to have been using that in under the USPTO, under the federal. Then you can do both. So you can either do like, oh, I've been using this and I've been using this for this long, or I have an intent to use it, and you can start the application. And then at one point you're going to need to show that, a year has gone by, but now I'm actually using this mark. If you don't do that, then even if you kind of like reserve the mark saying I have the intent to use it, you're going to lose it. So that's the little issue there. And then, this is kind of like, between federal and Florida. And then you need to also consider, again, the mark needs to be somehow distinctive, needs to be different, okay? It cannot be something that is very obvious, I guess. So
are palm trees obvious?
I mean,
or no? I mean, I don't know. Because listen, again, these are not companies. These are not-for-profit corporations and their residences. And they may want to, like I said, add a little pizzazz, a little something that speaks to what life would be like in their community. Golf course communities, it's easy. Equestrian communities, it's easy. You add a horse and a rider on your on your design. So you're kind of putting it out there what you can expect with this lifestyle. But I would still think that most of the designs are going to be fairly basic.
It just needs to be not too generic, or just like kind of like only descriptive. And you can kind of like get around that with like other, in other ways. Like, you can kind of like draw the palms in a certain way, or draw the clubs in a certain way, make them so that they're not, like the standard palms maybe, or maybe you can include something in the palms design where it includes some of the letters. You can, like you can find ways around, a mark to make sure that it's a little bit like more original, I guess, right? The point is, you just need to be careful if you're just making, Island Club, and you're putting like a club and an island. Probably, I mean, that's kind of like, it's simple to think, hey, maybe this is not going to work very well for registration. It needs to be something that would be particular and can be remembered in a way.
I'm thinking there's some potential work for graphic artists out there who may be listening. Yes. To say, hey, I can do a great design for your community. But let me ask you something. Why would you go for a state registration as opposed to just doing federal? Does federal protection cover everything that the state mark would cover?
Yes. So the thing is, Florida will mean like you're just registering for Florida. And the idea is you're using the mark in Florida. So if somebody else is using the mark in New York, so sad, you cannot do anything about that. But if you're registering the federal level, then yes, that would be a registration that covers the entire US. It's just, I think it depends a little bit, like, I guess, on how big the association is. If you have, I know probably an association is not going to have like, an association here and one in another state. Right. That may not be the case. But, if you're an association that may have like products, for example, or maybe doing something else, or is like a bigger association, I probably think the federal is a little bit better. The main differences, I mean, first of all, let's talk about pricing, okay? Because we said like $87 for, Florida registration. That's pretty cheap. You need to renew that every 5 years, but again, still pretty cheap. If we go to federal, then at the federal level, we have two different types of registrations, two different types of application, for the registration. And you can either do the TAs plus or the TA standard. Depending on the type of application you prepare, then it's either 250 or 350. Still not a lot of money if you think of that. Again, this is always per mark per class. So if you have more than one class, then it's gonna, multiply that by the number of classes and you're gonna have the total. Still not a lot. The thing with the federal is that it's gonna give you protection all over the United States. It's gonna give you subject matter jurisdiction of federal courts over any sort of issue with the marks, because the moment you register with the USPTO, then you can go to federal court, and federal courts are a little bit more knowledgeable on trademarks and intellectual property issues than state court. So that's a little bit better protection, I guess. And the other thing is with the federal registration, after 5 years, so you do the first application, right? And you go through the process, and I will just tell you a little bit of how it works just for an idea, right? So you file the application, then the USPTO is gonna, if it's a design, the USPTO is gonna figure out if there is any specific thing that is associated with the design. So let's say you have, like you said, like the pubs and the clubs. So the USPTO is gonna say, okay, we see that the items associated with the design are pumps, clubs, and I don't know, like the lake, for example, right? And so that's going to be kind of embedded in the design, in the application. So if a similar trademark comes in and wants to be registered, that's going to also kind of trigger some sort of notice, hey, there is a similar mark. Once you file the application, you're probably not going to hear anything for 6 months.
I was going to ask about that, the review process.
The federal registration takes a while. So we're talking about, let's say, the marks that you've already been using in commerce. So you're going to file the application. It's probably going to be 6 months, probably even 8, I would say at this point. And then this is going to get assigned to trademark, that USPTO attorney. The examining attorney is going to look at your application and may get back to you and send you a notice of action and say, hey, we realize that, for example, you submitted some examples, some specimens, how we call them, and they're not, I don't think they show that you're using this mark in connection with this service or these products, or we don't think that the specimen you submitted looks great, or we think that you made a mistake with the class, or you didn't specify or detail or describe well what the services that you're providing are. So there may be a lot of things that come with the notice from the USPTO. You're going to have probably 3 months usually to respond to the USPTO notice. And then once that's kind of cleared, you may get nothing. But I would say that USPTO has been very focused on making sure things are done a little bit more by the book lately than they were doing before. And that's just my opinion, of course, but that's how I think things have been going. So let's say you get the notice, you respond, or you get no notice, everything goes well. Then at one point, you're going to get notice of publication, which means that the mark is getting published, and there's going to be an opportunity for people that are using something similar to file an opposition, or to say, within 30 days from the publication, to say, hey, I have a similar mark and I've been using this for way longer than these people have, right? So let's say nothing happens, everything goes well. After the publication, after the period goes by, at one point, finally, you're going to get your mark registered. So it takes, I would say, probably a year and a half, even more sometimes, depending how long, if you get a notice, if you get an opposition, if you get any sort of issues, but it takes a while.
If your application is pending with the USPTO and somebody else has registered something very similar, do they alert you to that?
If they try to register when you're ready submitting the application, so they're coming after you?
When you've already, your application preceded theirs, but it's pending. Like you said, this could be a lengthy process federally.
So what happens is that the moment you send the application, really nothing is happening. The moment where things are actually being reviewed, there is actually 2 moments where things are going to be reviewed and can come into issue. One point is when it gets assigned to the examining attorney. So the USPTO attorney is going to look at things and is going to look you should be looking before you register your mark, of course, but it's going to do like another check. He or she's going to do another check, and it's going to look for other marks that are similar. So when the time comes, the USPTO attorney is going to say, hey, you mark number 2 in time, they try to register after this other mark came in. Please know that there is this other mark that is there. But the point is, usually if you applied first, you're probably going to get like protection, unless there is like some issue. Keep in mind, if you get the registration, so if you go through the entire process and you get it registered, the registration is good, and it's good as of the day you apply. So it's not going to be good as the moment you get the certificate that says, hey, it's been registered. It's going to be just the first moment that you applied, which is very good because it covers all the time that you were in the application process, right?
What's the filing fee for the federal mark?
So for federal, so as I said, there are like 2 different types of filings you can do. Well, 2 different types of systems you can use when you file. So up to a few years ago, we only had one system, which was the TS standard, and now we also have the TS Plus. Sounds weird, but the Plus actually costs less money. It's $250 if you're using the Plus, and it's $350 if you're using the standard. The Plus, you can use the Plus, and I would suggest the Plus is probably better when you can qualify for that. It's just like a little bit more detailed, and it's going to ask you to kind of like fit in certain boxes, let's say. So the USPTO has specific list of like classes and a specific description of the classes and what is included within the classes. So if you can fit in those descriptions, then you can use the Plus. If you're registering your mark for a very peculiar service or a very peculiar good or product that is not within those descriptions, then you may need to use the standard. The standard usually also takes a little bit longer in the review process because, again, in the Plus, you're trying to provide more information and kind of like go more by their rules and their, definitions already. So it's usually easier. I usually use the Plus when I can.
I was going to ask you, what do you recommend, Valeria, for a community association? Would it be the Plus?
Yeah, the Plus is usually easier. Again, cost less money. So there is no reason to go for the more expensive one if you can avail yourself of the cheaper one. Plus, again, it also depends on the class. As I said, you use the standard when the class and the descriptions that are contained within the class in the Plus descriptions are not really good for you. For community associations, what you're looking at is probably, services that are related to protecting the community, making sure to enforce the rules and regulation, marketing the community. Those are pretty kind of like standard services, right? But if you were a different business, right, and you have a product and that product is not within the description, you're making a complete different, I don't know, piece of clothing or some sort of like weird item, then you may want to do the standard because that way you're going to be more protected and you're just going to say, hey, this is what I'm doing. And again, classes are the way they work is basically classes try to include within their descriptions different things that are related to the same category. So for real estate associations, I think it's easier. For community association, I think it's easier because again, the type of services you're going to provide are pretty much standard things. But if you have goods, you can have different types of goods. You can have different even within the clothing, you can have different things. So if I'm registering a product and I'm registering under, class, clothing, but I'm just doing shirts, I need to say shirts. And somebody else may come later and say, hey, I'm just doing baseball caps. You're not doing baseball caps. In theory, I could do baseball caps now. That's why it's important to make sure when you have the class that you're kind of including whatever could be important to you.
I hope nobody's trying to do this on their own. after talking
to the USPTO, defense, I guess they try to make the process easier if possible, and it does look kind of easy, but the problem is that, and that's what I see most of the time, people try to register things and they just end up getting a notice of action because something wasn't proper, or you're just not providing things the way they like it, you're not describing the class correctly. It's not complicated per se, but I think it's really not that expensive to get some help. It's really maybe a few hours of help to make sure that things are done properly, and it's better to be
I
guided.
wish everybody took that advice across the board. But you said a few minutes ago that if you get the mark, you have to enforce, use it or lose it. You have to protect it. If you don't, you could be deemed legally to have abandoned it. So I'm thinking, I'm an association in Texas. For whatever reason, the board has decided to register our mark through the USPTO, but we did not do it through Texas. Okay. Now, isn't it going to be, and it's granted, they love our name, they love our mark, whatever. It's granted, it's registered, we have it. And I want to talk to you about the little TM and the little,
Yes.
that we see. So they have the little TM, they've got everything. Now, do they have to be looking in all 50 states to make sure there's nobody in Florida using their same name and mark? I mean, I would think that's a lot more difficult than just making sure nobody in Texas is using their mark.
So I think when it comes to enforcing, I think it needs to be kind of like a common sense sort of like approach, meaning, I think it makes sense for you to kind of like once in a while, Google, see if anybody's using something similar to your name or your logo. That's something you can do, right? Do you need to actively go in, I don't know, like in South Dakota, if you're in Florida, and probably not, okay? The point is, if something is happening and something is happening and somebody's using your name or your logo or your mark or whatever you want to call it, okay? Whether it's like common law or it's registered or whatever it is, but it's clear that it's creating some confusion. That's the biggest issue, right? Creating confusion, or it's damaging your reputation, your name, your goodwill, then I think you need to take action. That's where really it becomes, that's where it really gets to the point that, you need to do something. You know something, you do something.
Are there companies that monitor trademarks where they will go online and search to see if anybody's violating your trademark?
I'm sure you can have something like that, but I mean, I've never used them, to be honest with you. It's just most of the time you will know, like when somebody, and I'm saying that for association specifically, because most of the time when somebody is using your name, your logo, you're probably going to find out, because somebody is like a resident or somebody is interested in the association is going to say, hey, I thought this was you, and it's somebody else that is using your logo, your name, or something like that. For products, that's different. Again, like, if you are, buying a pair of Louboutin shoes and they're not Louboutin, I'm sure they have something in place to make sure that nobody is using their, trademarks for other products. But I don't think that's really applicable to association. Again, we wanna make sure that we have like a kind of like common sense approach. We're not trying to make it like super complicated or super expensive. Just try to be careful and try to look out. If you see somebody that has, web page or social media or something like that, and it's using your exact same name and is acting like it's the association, you probably need to do something about that.
Let's talk about doing something. So we find out somebody's using our registered mark. We send an initial demand letter and we get no response. Where do we go next? Circuit court?
Depending on where you registered. Again, if you register. So if let's say you're in Florida, just because this is easier, right? So let's say you're in Florida and you haven't registered anywhere. It's going to be a little bit harder because you're going to have to show that, you're using a mark, and that mark is really distinctive. People know that that's the mark you've been using, and this person or this company is using your mark for similar activities or similar services, or is doing something that is actually harming you. So it's going to be a little bit like harder. The burden of proof is going to be a little bit harder, but you can probably file in state court. You're not going to be able to go to federal court because you haven't registered your mark at the federal level. If you're registered at the state level, so you're registered in Florida, same thing, you're going to go to state court. You have a presumption here, however, that since you registered the mark in Florida, that this mark has been used since the day you said it was used, in the way you said it was used, and it's going to make your life a little bit easier in court. And if you are at the federal level, so if you register at the federal level, you have a choice. I would say go to the federal court, because federal court is just going to be, again, they're like a little bit better, more knowledgeable when it comes to intellectual property. So I think that's the way to go. But again, like, you have different ways to act depending on what you have. You're going to have different, the thing to keep in mind is you may be entitled to different damages, whether you're registered or not. If you're not registered, you're probably going to be, first of all, you're going to have like a tougher time kind of like proving this is my mark, I've been using it, and this person has been using it in a way that it's confusing or it's diluting my mark. And secondly, it's going to be a little bit harder for you to get certain type of damages. So, loss of profits, it's probably not going to be possible for you to get lots of profits or something like that if you didn't register.
Can you talk to us about the little TM and the little C?
So everybody is like kind of like confused about that, I guess.
Yes.
Right? Okay, so there are three different like things we see usually associated with marks, right? So you see the little TM in the circle. Sometimes, this is not very common, but I've seen it sometimes. You see the SM in the circle, and then you have the R in the circle, right? So these are the three different ones. Okay, so the SM, which is the one that is less known, that's for service marks. So that's really what it is. Okay, so if you're using a mark for services, that you can use that, and you can use that SM with the little circle even without registration. You're just saying, I've been using this for a while, this is distinctive, and this is my mark. Fine. Same thing with the TM. So the TM, you don't need registration for that. You need to, again, like you need to have been using this mark. It's not like you can wake up one day and say, oh, I got this mark just now, and now I'm going to say that, you know, this is my mark and everybody knows it's mine. But the point is, under common law, you can use TM, it's fine. The R, that's where, you know, it's different. To use the little R, you're going to need federal registration. So not even state, you need federal registration. If you use the R without the federal registration, you're basically doing something wrong.
I was going to ask you, are there penalties if you're putting these little symbols on your letterhead or what have you, and you haven't, and you're not entitled to it? So let's say I'm putting R on my association letterhead. Anybody who knows this, which I'm assuming is not going to be that many people, but anybody who knows the intricacies of the law will go, wait a second, do they have a federal registration for this? Are there penalties if you use it, knowing you shouldn't?
I mean, that's really probably, let's put it this way, like you shouldn't use it, okay? But is something going to happen? The likelihood that something coming after you because you're using the R when you're not entitled to that is probably not that high. I'm just being like very, you know, like down to earth here.
Right.
And it's just
but
like,
don't do it, people. Don't do it.
Just don't do it. But I mean, like, it's probably not going to happen. But what can happen is if you're using a mark and it's actually registered by somebody else, and you're putting the little R, that, you know, that's all great because you're basically showing you're intentionally using somebody else's mark. So, you know, you have that intentional part that it's going to make your damages even worse, if possible, if somebody comes after you.
Do you think that more developers of these communities should consider trademarking the community association name and design before turning over? I'm always shocked that they don't do this, especially for the very upscale communities. They give a lot, but I would think that that would be an added value to say when you're turning over as a developer. And by the way, we've protected your name and design.
I mean, I agree. I think, again, especially if you're kind of like high end, it's something that adds to your, you know, like your image, your value, your reputation. Like people are going to know you and they're going to see you as a, I guess, more established, more high end, just because you have something that really strikes them because you have this design or this logo or something like that. And again, it's just like, it's probably just also because you're going to feel part of something, you know, you're part of the association and you know that that logo means the association and you're a resident of the association. I think it's always great to have something that you feel like you belong there. I guess, you know, this is it's not like very legal, but it's true. You know, it's nice to say, hey, you know, this is my association, this is our logo, we're doing all these great things, and you see that around being used.
No, you hit on something very important because you're selling a lifestyle. You know, you're not just selling a building in a condo, and you're not just selling a single family homes. You're selling a whole concept, a lifestyle concept. So, you know, and I don't want to name names of certain communities, but I can think when I drive in and I see a beautiful sign with the, beautiful design that goes with it, and they've got the mark registered. It does give a different impression, I think. So I really am surprised that more developers don't think about it. But as you know, and I know because I've asked you to work on this, that it doesn't matter if your developer overlooked that little fact, you can do it after the fact.
Yeah, absolutely. And again, it's even though you're not like a profit corporation, it's still goodwill associated with the association. It's still something that, whether it's done by the developer, it's done after by the association, it's something that is going to stay with the association for the long term. And I think it does add value. So I think it's important to do that, especially if you're high end, it makes no sense for you not to do it, frankly.
Well, I was going to wrap up by asking you what your favorite trademarks are, but it's pretty obvious that it's Louboutin shoes and Apple devices.
Tiffany, you forgot Tiffany, you know.
Oh, and Tiffany.
We're gonna send a recording to my husband just in case, okay?
All right, mine too. Listen, thanks so much for joining us today. This has been really, really useful information, and I hope more communities think about potentially trademarking and protecting their names.
Yes, absolutely. And if anybody has questions, I know it's not that easy, but that's when your condo association attorney comes in, and it's important to speak with them and see what their advice is, because you may provide the best advice and tell them whether they can do it or not. Sometimes you cannot do it, sometimes you can.
Lastly, where can people find you?
Oh, I'm in the Fort Lauderdale office of Becker, and so if they can find you, they can find me, I guess. Becker and Polyakov. I think you have my name, my phone number, my email are all on the website, but it's basically Angelucci@beckerlawyers.com.
And we'll put that in our show notes. Thanks again, Valeria. Thank you for joining us today. Don't forget to follow and rate us on your favorite podcast platform, or visit takeittotheboard.com for more ways to connect.